accessible understanding of natural law. Today, on The Simple Truth, we consecrate everything to the Sacred Heart of Jesus through the Immaculate Heart of Mary and the pure, strong, chaste heart of St. Joseph. I'm your host, Jim Havens, and our guest today is Dr. Hadley Arkes. He is a distinguished political scientist, legal theorist, and constitutional scholar, professor emeritus at Amherst College, founding director of the James Wilson Institute on Natural Rights and the American Founding. JamesWilsonInstitute.org is where you can find it. Also the architect of the Born Alive Infants Protection Act and author of several books, including the one he's here to share with us today, Mere Natural Law, Originalism, and the Anchoring Truths of the Constitution. And Mere Natural Law, fantastic book. I read every word of it, and it's one that I'm going to continue to study and learn from. But in this book, Mere Natural Law, this distills Professor Arkes' lifetime of reflection on natural law, constitutional jurisprudence, and the moral foundations of legal reasoning, all in a sort of common sense understanding that is very helpful to us. So, Dr. Hadley Arkes, welcome back to The Simple Truth. How are you today?
I'm fine. That was a fine, quick description of the book. I think I'll stop with that one. You've done very well.
No, we're going to need you to unpack it for us. So we only have an hour.
I knew there was a
Only have an hour, and there's so much in here. So yeah, wherever you want to go today, but it's great to have you with us. Let's begin here with the title, Mere Natural Law, evoking C.S. Lewis's Mere Christianity. What core truth were you trying to lay bare in this title, and what misconceptions about natural law did you most want to correct?
The appeal to C.S. Lewis, Mere Christianity, C.S. Lewis encompassed the recognition of the way young people would argue about things. And they're having real arguments, not merely expressions of their feelings, but arguments. And the conversation made no sense unless everybody assumed on each side that there were standards for judging right and wrong answers. That even youngsters have an access to certain principles of judgment. And they were bringing us back to what Thomas Reid, the great Scott philosopher of the 18th century, who's so read closely by James Wilson and John Adams among the founders. Thomas Reid was getting at those precepts of common sense that precede theories, the things that the ordinary man has to know before he starts trafficking in theories. Those precepts, as Reid says, that the ordinary man would not only have to know, but virtually take for granted in getting on with the business of life. He knows that for every effect, something must have caused it. So the ordinary man might not be, say, bantering with David Hume about the meaning of causation, but the ordinary man knows that he has his own active powers to cause his own acts to happen. So what I was trying to do was draw us back to the way in which founders like James Wilson would be drawn to that point, to those precepts that were there before people were working with different theories of law, to the precepts that were always there, And so bringing us back to the principles of right that were there, the principles of lawfulness that were there before the Constitution that the founders could draw upon, and the principles they would know would be there even if there were no Constitution. And so, for example, for that, the very first principle of all moral and legal judgment, expressed by Kant in this way, for example, that it makes absolutely no sense to cast judgments of blame or praise on people who had no active powers to cause their own acts to happen. The great Thomas Reid says that proposition is as true as anything you could find, any axiom you can find in Euclid. Now, what I'm trying to show is that we can indeed find the ground of the natural law and things of that kind that are accessible to ordinary people, even people who are not burdened with a legal education. You know, there's a great letter of Thomas Jefferson to Peter Carr, in which he said, you can give the same moral question to a plowman and a professor, and the plowman was apt to get it right, because his thinking will not be deflected or distracted by artificial rules. Call them theories. And people who go to law schools are just amply supplied with theories. But it may be useful to go back to the kinds of things that are so necessary. So much so that as we would say, the ordinary person just has to take them for granted in getting on with the business of life. That we find the ground of our understanding of natural law there. I think you may recall, Jim, that I mentioned that former president of my college who said that Hadley has a theory of natural law. And I said, when you say something like that, you suggest that you're standing back in wholesome detachment, watching theories whiz past. And somehow you're able to form a judgment on the strands of those theories that are plausible or implausible, true or false. And I said, take me back to the ground on which you're making those judgments about the things you reliably know, and you'll be taking us back to the ground. Some of us do, in fact, take to be the ground of the natural law. Yes, so that was the casting the point. So I'm trying to get back to things that we had to know. The ordinary person without a college education, without a legal education, would know and has to know, and take that as the ground of a natural law that is accessible to ordinary people. And it was also brought us back to the grounds of moral judgment. Grounds of moral judgment that the phone is ringing here. Grounds of moral judgment that the founders understood before they made the Constitution, and those principles that they knew would be there even if we didn't have a Constitution. Just as John Quincy Adams said, that right to petition the government, that would be there. It's implicit in the very idea of a free society. It would be there even if it hadn't been mentioned in the First Amendment. It would be there even if there were no First Amendment. In fact, it would be there even if there were no Constitution. So what I'm trying to do is clear the way, the distractions, and bring us back to those anchoring grounds of things we have to know before we start making a Constitution.
Yes, yeah. The first definition of natural law that you provide in the book is from Cicero in his Republic. Quote, there will not be different laws at Rome and at Athens, or different laws now and in the future, but one eternal and unchangeable law will be valid for all nations and all times, end of quote. You make a couple of important distinctions here that you claim ordinary people understand to be common sense that demonstrate that most believe in natural law. The first of these distinctions between wrongs that are contingent on matters of degree or circumstance and wrongs that are categorical, meaning there are wrongs that are wrong in all instances, in all times and places. For example, most ordinary people have the common sense to say that even a little genocide is in moderation is wrong. You write also that the same ordinary man is likely to grasp immediately the sense of practical ranking or ordering of rights. And here's the second distinction between rights that arise from nature that will hold for all people in all places and rights that arise from membership in certain communities. For example, everyone has a right not to be mugged or assaulted, but not everyone has a right to use the squash courts at Amherst College. You write that any ordinary person will readily grasp these distinctions, even if he doesn't have a college degree, and yet he may not realize that he's touching the core of the gravest argument that has ever arisen in our politics, in our crisis of the House divided, the argument engaged on the classic debates between Abraham Lincoln and Stephen Douglas, an argument that ran to the moral root of the American regime. You write, the heart of the question was whether those unalienable rights mentioned in the Declaration of Independence were rights grounded in nature, or if they were simply rights that could be created or withdrawn by the authorities in any place, as in the right to use the squash courts. Lincoln was on the side of rights grounded in nature or natural rights. Tell us more of this.
Well, just where to pick it up. No, the example I used, I think, in the book was the visitor comes off the plane in New York. We don't have to look at his passport to grasp whether he has a right to be protected from a lawless assault in the street. But he doesn't have the right to take himself over to the City College of New York and get that subsidized rate of tuition. When we're talking about in that argument between Lincoln and Douglas, Lincoln thought that the rights of the black men here had a natural foundation. They didn't depend on the positive law, the law that is passed in any place. So Lincoln would say, the question is whether the black man is or is not a man. If he is not a man, then anyone who is a man can do with him what he wished. But if he is a man, he too would have the right to govern himself. Now, for Douglas, it's interesting that Douglas, that right of the man to govern himself stood in the class of those things that may be granted to us in the positive law. Rather like whether you're going to have access to the City College of New York, whether the majority are quite willing to consider you a person either fit for the City College of New York or a person even to be fit for slavery. So the argument was there are certain of these things that simply, those things that will flow to nature to all human beings wherever they are. So the question becomes, well, what is a human being? You've seen that that Lincoln used that wonderful fragment he wrote for himself. He gave us a model of natural law as he deliberated on the question. So imagine he was engaged with an owner of slaves, putting the question, how do you justify making a slave the black man? Is it because, I see we have an interruption coming up. We have a break coming up?
Yes, we do. Yeah, okay. We'll hit the break and then come right back to you, Professor Arkes. But yeah, what you're saying is very, very important here, and that it really is common sense, and most people grasp it even if they don't maybe realize it, that some wrongs are categorically wrong. And the killing, the direct intentional killing of an innocent human being, an innocent human person, that is always wrong. So this should be clear. There should be no such thing as abortion in our law, in our land. And then we have the opposite, which is Justice Anthony Kennedy, his majority opinion in Planned Parenthood versus Casey, where he says, at the heart of liberty is the right to define one's own concept of existence, meaning, the universe, the mystery of human life. We're going to be right back. Stay tuned. Simple Truth. Jim Havens here with our guest today, Professor Dr. Hadley Arkes. We are talking about his book, Mere Natural Law, Originalism and the Anchoring Truths of the Constitution. And we had to cut you off a little bit as we were hitting the break there. Sorry about that, Professor, but feel free to continue on.
Well, you teed things up very nicely for me, Jim, because that question, moving into the question, who is the bearer of those rights? I was recalling, actually in that vein, I recall a student of mine came to the office and said, he told me he wasn't really as enamored of natural rights as I've been. And I said, well, why is that? And then the conversation turned to that character in the gutter who's broken himself. And I say, why is it that we still view that man as kind of a bearer of rights? And then my student did a kind of postmodern song and dance. It was because of the lens with which we viewed him through our culture. I said, whoa, stop. You're talking about us. You're talking about our lens. And you start talking about is him. Tell me, what is there about him that you think makes us the bearer of rights? Now, Lincoln would say, nothing made in the divine image was sent into this world to be imputed, to be treated as a nothing. So the question will always come back about what is the nature of that being whom we regard as the bearer of rights? And Lincoln had that notable fragment he'd written for himself, in which he imagined himself in a conversation with an owner of slaves, putting the question, why are you justified making a slave the black man? Is it because he's less intelligent than you? Well, beware, the next white man who comes along more intelligent than you may rightfully enslave you. Was it because he's darker than you are, with the light skin having the right to enslave the darker? And Lincoln said, beware again, you may be rightly enslaved by that measure by the next white man who comes along with a complexion even lighter than yours. The upshot is that there's nothing you could cite that could provide a ground of justification that for enslaving the black man that have now applied to many whites as well. And as you know, Jim, we simply used, as the Catholic Church used, just the same kind of principled reasoning when it comes to abortion. We ask, why is that small nascent life in the womb not yet human? Doesn't speak yet? Well, other beings don't speak. Deaf mutes may not speak. It doesn't have arms or legs yet. Well, other beings, people lose arms or legs without losing anything necessary to their standing as human beings to receive the protection of the law. We discovered there's nothing you could cite to rule out the unborn child as a human being, claiming the protection of the law, that would not extend to many many people walking about well outside the womb. And here's the problem that the court got into in the Dobbs case when it overruled Roe versus Wade. It simply wanted to say that abortion is not contained in the Constitution, therefore the judges have no reason to proclaim a right to abortion. But of course, the federal government had ample reason to deal with the matter of abortion long before that. It had to deal with abortion in military hospitals, diplomatic outposts abroad. It had to deal with abortion in the territory of the United States, even the District of Columbia. What the court did was simply strike down Roe, but remarkably, 6 conservative judges in striking down Roe could not bring themselves to say that that small being in the womb was indeed a human being. If they recognized that it was a human being, then many other things would fall into place. The 14th Amendment would fall into place, that the powers of Congress could be invoked along with federal judges if the blue states begin withdrawing the protections of the law from a whole class of human beings. And after all, remember, the laws on murder and homicide were quite indifferent to the size and weight of the human victims. And if the court had really recognized that we're dealing with a human being, small human beings, then of course the litigation over mifepristone, chemical abortions, would be dramatically altered, because when the question comes, it could not be confined to the question of how safe is this drug for the woman who's taking it. Because if we'd recognize that we're dealing in the child with a small human being, then another person would be in the picture. It would be profound. It'd make a profound difference to consider how that the status of that drug as a device meant to destroy one of those persons in the picture, the child in the womb. So again, what we're dealing with are those central questions about how you understand the nature of that being who's subject to the protections of the law, and then of course the gradations would come into play. Why that people may have a claim to be protected against lawless assaults on their lives, while putting at another level the right of people to get access to subsidized higher education in New York City. We recognize a gradation of these things, but it starts by recognizing the nature of that human person, as John Paul II said. And what I was doing here was calling the way that the church reasons about abortion. The church never appeals to faith or belief. The church approaches abortion with a combination of science, the findings of embryology, woven together with principled reasoning, which is why it was quite striking that we have one Catholic member of the Supreme Court, Justice Kavanaugh, in the Dobbs case, saying, well, isn't it interesting how many pro-lifers actually believe that the fetus is human, as though we didn't have almost 100 years of embryology that would give us a very precise answer to the question of when human life begins. It's a matter of, in other words, he doesn't think about abortion in the way that the church reasons about abortion. He's learned to view abortion through the lens of a theory of conservative jurisprudence, which instructs the judges to go out of their way to avoid addressing those questions of moral substance that lay at the heart of the case, to try to leave those questions as much as possible in the hands of people who are elected.
Yes, you write that, quote, "It is a curious mark of our time that a defense of the American founding and its grounding in natural law should be taken as conservative in our politics." And then you say, you talk about that the reason it has become so is because the left today wants to deny the fact that natural law supplied for the founding and anchoring moral truth about the rightful and wrongful governance of human beings. But then you also write that in our time, natural law has become every bit as much scorned by conservative jurisprudence. So it's getting beaten up on both sides here. And it's strange because, again, it's common sense. So it's strange that it's all getting lost. But where do we go back to see where we started to go wrong here? You write about Justice Holmes a few times in this book, I noticed. Who was Justice Holmes? What did he do was he the beginning of things going off the wrong track?
Now, here's a reflection of things moving in another direction. Of course, this becomes. We could start sounding like Brian Lamb on C-SPAN. Who again was Lincoln? Like who again? Justice Holmes was one of the most highly bred thugs that that this country has produced. A man who fought in the Civil War, a graduate of Harvard. A critical figure in the teaching of law in Massachusetts, became a member of the Supreme Court of Massachusetts, and was eventually elevated to the Supreme Court. He came out of the Civil War quite shaken and quite broken from any conviction that what was bringing forth this carnage and this violence were genuine moral truths. All he sold were strong convictions held on either side. And he said, a moral appeal is simply appeal to the things I really believe in and can't stop believing. But he didn't really think they were just moral truths. They're just things that just, for some reason or other, compel the credence of different people. And he said the only what he meant by universal truth was the truth accepted in that country that could lick all others, which is to say, might makes right. And in fact, you get that when the same thing. When the question was posed to Justice Holmes, is on what ground does the majority rule the minority? On the ground that the majority can overpower the minority, that it has the brute strength to overpower. And regrettably, it was the same answer given by my late friend Justice Scalia, that the Constitution put these rights aside, to overturn the majority, but the whole thing depends finally on the rule of a majority. And if there are any other principles there, we have to have a consensus on any of those principles we invoke. But of course, it's incomplete the truth that any. He used to say we don't have a consensus on these principles of natural law. To which his friends would say, "Did you get kind of consensus on that point? Did you ever give us a ballot?" It simply becomes one of those well-earned fallacies that in the present, when there's disagreement, there can be no truth. And of course, now I simply record my own disagreement with that proposition, and it dissolves. It's one of those self-refuting propositions. But we find that Scalia and Justice Gorsuch and others would agree that even people who call themselves originalists, who are looking for some other non-moral ground for their jurisprudence, even people who are originalists will disagree. Yet the fact that they disagree does not mean that originalism has no truths to discern. And the same way, the fact that people may disagree in moral arguments does not mean that there are no moral truths there that reason can discern. Well, Holmes was the breakaway, and Holmes is that classic passage in The Path of the Law, 1897, which I cited. He hoped that every word of moral significance could be purged from the law altogether. These moral judgments were simply emotive. They're simply reflections of what people felt. That there are no cognitive truths, real truths, that had to be recognized by any rational creature that lying behind all these things. So if you take that ground, he was perfectly willing to go with the vote of a majority to establish these laws on compulsory sterilization. In Virginia, in the famous case of Buck versus Bell, of Carrie Buck, who was thought to be retarded, and it was assumed that her child was retarded. And the one way of dealing with the problem was to sterilize her. That wouldn't improve her condition, but it would make it impossible for her to perpetrate her like. So, but Holmes would go along with that simply because it was the vote of majority on something he cared about. He cared about euthanasia. He cared about making the race better by sterilizing those people who are not as fit to live. It was a kind of thuggery covered over with all the trappings of a Harvard education and the elegance of a man who had studied Greek and could cite the Greek. But it shows you could have various levels of vulgarity, even with a higher education.
Yeah, you write also that I think this is part of the solution here. You write the need to engage the very substance of the issue, whether it is the undeniable human standing of the child in the womb or the moral incoherence of the, quote, right to declare one's own sex. Nothing less will settle or resolve these issues or give us the framework for living civilly together, even as we continue to be morally divided. Again, the need to engage the very substance of the issue. And this is exactly what the court did not do in Dobbs, was address the actual substance of the issue. When do our inalienable rights begin? The first of which is the right to life. What is the child in the womb? It is a human person from conception, fertilization. They refused to actually engage the very substance of the issue. You have a great chapter on that and so much more in the book. We'll be right back. Stay tuned. Back to the Simple Truth. Jim Havens here with our guest today, Dr. Hadley Arkes. His book, Mere Natural Law, is what we are discussing. Highly recommend it. Get it wherever you find books. And if you have it, read it, reread it, study it. Phenomenal stuff. Pass it on to any possible aspiring lawyers in your midst or lawyers you may know. I think this would be very helpful. Any judges, if you know any judges, this would also be good for them to read. But Hadley, the 14th Amendment protects the life of any person under the law. What's the strongest argument that the preborn already fall under that protection? And what do you think it would take to actually get the courts to admit it?
Well, it's all they have. I think it's silly debating over the question of what is a person. If it's a human being, it's a human being. How does the American regime begins with the Declaration of Independence, with the natural right to people to have a protection of their lives, their liberties. That one of the central commands, purposes of this government is to protect people from the lawless, unjustified taking of their lives. There used to be no question about this. If you put the question to James Wilson, when do our natural rights begin? His answer, James Wilson, I should go back, Jim, I suppose. James Wilson, after whom our institute is named, was one of the premier minds of the American founders. He's a Scot, born a Scot, and came to this country in his 20s. He was the signer of the Declaration of Independence and the Constitution. He's a leading voice in the Constitutional Convention. He went on to be a member of the first Supreme Court, and he got on to give these utterly elegant lectures on law at the University of Pennsylvania that are contained in books of his works. But he said, when do natural rights begin? He said, they begin as soon as we begin to be, which is why, as he said, the common law casts its protection over human life from the first stirrings of the womb, meaning as soon as we know it was there. And another book of mine, Natural Rights and the Right to Choose, about where I took up in part a memoir for our Born Alive Infants Protection Act to protect the child who survived abortion. In that book, I recalled this shooting at an abortion clinic in Brookline, Massachusetts. And several nights later, there was a candlelight vigil. And one woman was there with her newborn daughter saying, I'm here to protect the rights of my newborn daughter to her reproductive rights. We said, oh, really? She had reproductive rights. And drawing on Wilson, we get, when did those rights begin? If they're a species of natural rights, then if we follow Wilson, she had those rights while she was in the womb as a living human being. But if that were the case, that would call into question the right to abortion. So the answer must be that that daughter received her rights when the mother, in a grand Nietzschean gesture, says, I now confer upon you the right to live, because there is nothing in that decision that's incompatible with my interests. Well, if that's the case, if that's the story of how we get any of our rights, then my right not to be assaulted, have my life threatened in a non-justified way, my right to life is on the same plane as my right to use the squash courts at Amherst. In other words, it's a right that is conferred by the powerful that will be there only as long as they continue to serve the interests of the powerful. By that notion, the right to abortion is simply stripped of its moral logic. It's something that can be conferred by the powerful and taken away when it no longer suits the interests of the powerful. So that again, that takes us back. Now, I drifted away from your main question, which is about the bearer of those rights.
I don't think so. No, I think it's right on point. But I will ask this as a follow-up. Could someone, a father, a grandparent, a guardian ad litem even, could someone have legal standing to sue the government on behalf of a preborn child? Does a preborn child have any standing in our legal tradition at this point, or does anyone have legal standing to sue on behalf of a preborn child?
Well, it's one of those awkwardnesses, that the preborn child could be an heir. That preborn child has a claim to an inheritance. Ronald Reagan once posed that question: What if could a woman kill her child and make herself the sole heir of her husband? So it was the old problem of how is it in our law an unborn child could have a claim for damages against a reckless driver, but no claim against the surgeon that would take a scalpel and hideous instruments to dismantle him or dismember him. That's one of those oddities. Now, of course, if we have the recognition that we're dealing here with a human being, then virtually anyone could come in to sue. It's remember, it's like the question about. I once posed the question, I guess the first things, about the right to self-defense, that you have this traveling salesman, let's say Jones, who's set upon by a mob in a southern town. There's a mob after him. And we realized that he could use lethal force to resist being taken and lynched by that local mob. But the question is, could a third person just use a threat on his own, use a weapon to defend this man? And the crowd said to him, "What's your concern here? It's not your life that's being threatened. He has self-defense, but what do you have to say?" And I think it leads us to a very critical point, that the defense of a principle, the defense of a right, may be wholly indifferent to the question of who is the agent who defends that right. I mean, if you take a look at Rome at the time of Cicero, there were no police, there were no municipal police. Someone like Cicero had to have his own bodyguards. In order to move to a police force, we had to undergo a kind of a moral transition. We had to understand why we could empower other people who are not the victims, who are not the people threatened by assault, empower these other people to act on behalf of the victims, even though they themselves were not the putative victims. So remember, we've had people coming in to act as guardians ad litems for the child who's being threatened with abortion, and people go, "Well, who are you? You're not a member of the family." And the answer is, it doesn't matter who we are. It doesn't matter who we are. If this is, again, one of those simple things that would have been transformed if 6 conservative judges could have been moved themselves to draw the conclusion emerging from all the evidence of embryology, that we know we're not agnostic on the question of what is the nature of that being in the womb. We're dealing with a being that has been nothing other than a human being from its very first moments. Once we recognize that, and then we understand what an abortion is, once we recognize it's a human being, then, as you've seen me say, the axis shifts. And then the question is, the ground on which we must justify the taking of that small life must be on the same plane as those justifications we demand in every other instance for the taking of a human life. It'll be convenient to do it. It'll be easier to finish school. It'll be a matter of avoiding embarrassment No, those things just don't wash as justifications in other cases for the taking of life. If the court could, and we can become clear in the very first place on the inescapable truth of the matter, that we're dealing here with a human life, then everything falls into place. We're no longer in the dark in some abstruse problem of what constitutes a person. We're dealing with a human life. The Constitution can cast its protection over human life. That was the very purpose of the regime, as marked in the Declaration of Independence. That natural rights to, not to everything, but natural rights not to have our liberties taken, our lives destroyed without justification. Once we're clear that we're dealing with a human being, all of those other things fall into place. Now, Justice Alito, in a marvelous scheme of reasoning, pointed out that no, you can't use a test of consciousness as to whether that infant, that fetus in the womb is a human being, because there may be grown-ups or people out of the womb who will fail on some test of consciousness. And so what Alito, and as Alito would say, if we can protect that unborn child at the point of viability, then why can't we protect the same child before viability? The fact that it's weak does not mean that we never thought that weakness becomes a ground on which people lose their rights. Weakness becomes a ground on which we are summoned to offer protection and care. So Alito brought us to the point of recognizing that there's no principled ground on which we could call that unborn entity in the womb as anything other than a human life, but he felt constrained from drawing the conclusion that came out of his argument, and he felt constrained because obviously he did not have with him 5 members of his team, five conservative members of the court, who were willing to come down to recognize that point, that we're dealing here with nothing less than a human being. The other conservatives were quite content to take the low door under the wall, or the most modest way of dealing with the question, by saying, there's nothing in the Constitution about it, we can't declare anything about it, so we'll just put the issue back into the political arena to let politicians and ordinary citizens debate about the question. But they're sending the issue back into the political arena after the court for 50 years had been teaching the rightness and even the moral necessity of abortion. And there are no steps here taken to try to put into place an alternative moral understanding. What we needed here was something called the art of overruling, for the court to put in place gradually a different understanding, to lead people to say, yes, it would be justified to bar abortions when the fetal heartbeat can be heard, although the fetal heartbeat is not itself a sign of the beginning of the human life. But to lead the public step by step to agree, yeah, it's legitimate to restrict abortion at this point. And after a long chain of these things, it may be easier to take the next step and say, we are dealing with human life. And why don't we just recognize that none of these other conditions brought forth justify the taking of this small life could possibly survive any rigorous measure of what a justification. We're having something similar to this in now the Scrametti case on Tennessee about we're barring parents from choosing this dreadful transgendered surgeries, which have the effect of disfiguring the lives of young boys and girls, with mastectomies for young girls and so on. And it's all predicated on the falsehood, because there's no way in which these surgeries can convert a male into a female or a female into a male. They seek only cosmetic effects, and yet it's through disfiguring surgeries which require years of continuing treatment in hospitals. Now, the court is likely, I think, to sustain the laws of Tennessee in barring people from choosing for their children these horrific surgeries. But it looks as though that the court is more likely to rest its decision on simply respecting the judgment of the legislature in Tennessee on a controversial matter. But what it wants, but it seems inclined to hold back from invoking the inescapable objective truth that really does justify those laws in Tennessee, that there is no way to convert a male into female and a female to male. It's all predicated on a falsehood. And yet, here's the problem, Jim. The court cannot move itself to make that appeal to an inescapable substantive truth at the heart of the case.
Right. Yeah. And when we get back, we can talk about why that is the case, because again, it seems to make simple common sense to anybody else who's thinking about it that some things are categorically wrong. And we should be able to say that there are these anchoring truths. There is objective reality, objective morality, and every law is some sort of a judgment on morality. So it's just about, are we going to the principle at the heart of the thing and then reasoning from there, or are we just exerting our will? This is what we want, and then reasoning from there. We'll be right back. Stay tuned. Welcome back to The Simple Truth. Jim Havens here with Professor Dr. Hadley Arkes talking about his book, Mere Natural Law. Again, highly recommend it. Get it wherever you find books. Let's, I guess, go to, let me pose the question this way. And that is, let's say a seasoned lawyer or a judge, maybe they read your book and they're like, this is fascinating. I never really put this together before. I never really thought about this in this way. How can you help me? What should I be really focused on as I go forward? They have a desire to correct themselves, but they've been soaking in these errors since law school. What would you advise them to help them make the correction and try to help set things right as we go forward?
Well, just let's begin at the beginning of this thing with as Thomas Reed said, the notion that you don't hold people blameworthy or responsible for acts that are powerless to effect, that is what must be the anchoring axiom of moral judgment. That's one of the first principle. I'd say anyone can recognize that. What you do is give the judge, remind him of those things that the founders knew that were necessary truths. I mean, Alexander Hamilton, the Fairness 31 says, in disquisitions of all kind, but begin with certain primary truths or first principles that have to be grasped as per se nota, such as the fact that you don't hold people blameworthy for acts they were powerless to effect. We point out an earlier generation did it. We point out, if you ask the ordinary man now, why is it in the age of animal rights, we're still not signing our labor contracts with horses or cows? The ordinary man would just be puzzled. Why? Because the ordinary man grasps there's only one kind of creature who can do things such as make a promise, reckon his interests, sign a contract, and be held accountable to an obligation to respect that contract, even when it no longer accords with his interests, which is to say, as Aristotle says, there's only one kind of creature who's fit for political life. Or he's going back, he understands the anchoring truths of this republic as it was understood at the time. No man is by nature the ruler of other men in the way that God is by nature the ruler of men, and men are by nature the ruler of horses and dogs. The ordinary man grasps that, even if he can't lay out all the bibliography over all men are created equal, it flows from it. So what we do is we have many young judges coming over to us, and even many older judges now coming over to our side when they see there's nothing abstruse about it. It's not a theory. It's not a theory. It became very popular in the 30s and 40s, and she and my late friend Scalia to say, well, those moral claims to moral truth are all specious. We doubt there really are moral truths accessible to reason. Maybe as a Catholic, I believe in moral truths, but you can't depend on other people by reason to grasp moral truths. It's all a value judgment. It's a value judgment, as Nietzsche or Max Weber who told it. We say something has moral significance as we value it. So the question is, if a black man would have a claim to his liberty if we value, we impart value to treating him as a human being. And as apart from the question of, quite apart from how we feel about it, is there anything about him that just compels our recognition as a truth, as a fact? So as Scalia would say, he said that they would say, there's no legal ground on which we can establish the human standing of the child in the womb. We have too many varied opinions about it. All this assumes that there is no truth, that judges should be in a position to declare that we're dealing with politics governed by strong opinions on either side, and it's very important that judges do not get into that. They try to steer away from taking sides in these matters. So it's just as Justice Holmes said, my job is simply to let the herd get its way, to make sure that the people can go to hell and they could vote for thugs, but it's just our job to just let the majority get what it's want, instead of recognizing that there is a principle. There were principles that were there. They were not all put in the Constitution. For example, it's curious that the court only later discovered in the 20s the right of parents to govern the education of their own children. We have something now in this country I never thought I'd ever live to see. A legislature threatening punishment to parents who would seek counsel to children who are suffering confusion about their sexual identity and threaten to take these children away. And we say, is there not such a right on the part of parents? And Scalia would say, no, that was just substantive due process. That was something that the court raised in the 1920s, invoking the Due Process Clause to strike down some laws in Nebraska. There is no such right, parental rights, in the Constitution of the United States, in the text. But we're be reminded of now, and we're reminded by some young historians, such as Jonathan Gienapp, G-I-E-N-A-P-P, that the founders did not think it was necessary to put in the Constitution everything they knew. And in fact, the great Thomas, I'm losing the name of the great commentator from Michigan, Thomas Cooley, said the Due Process Clause was simply that device by which the judges could make their way to those principles of natural law that they never thought of putting in the Constitution. My friend Dick Helmholtz at the University of Chicago said, a summons. Shouldn't people targeted for crime know that they're going to be put on trial? Don't they have a right to receive a summons? Well, there's no mention of summons in the Constitution, Jim. The founders didn't think they had to put in everything they knew. And so the Due Process Clause was simply recognition that we would continue to deliberate about those rights, like the rights of parents that we never seem to doubt. And yet is called into serious question in our own day by legislatures in California, in other words. So we're trying to recall to people that you have a ground for deliberating about principles of right, of moral truths, that were there even though the founders did not think it necessary to stipulate those things. Well, people, well, look, we hear from our conservative friends, you find judges who are inflamed with moral conviction. They're sure there's a right to same-sex marriage. They're sure there was a powerful right to abortion. You see, when we give them a license to start deliberating on these questions with moral reasoning, that they'll come up with these just extraordinary, bizarre things. You say, well, the response to that, if people are having extravagant conclusions, is to show why this reasoning is specious. You don't deal with it by saying, you see what people are doing when they misuse moral reasoning. We'll show them. We'll avoid moral reasoning altogether. That has been the strategy of conservative jurisprudence. And what we're saying is that is not the path. That is not the path to morally coherent jurisprudence. And what we're finding recently, Jim, is that so many young lawyers are now on fire about this project of natural law. And what seems to be at work here is that they really think we can do better, that there's a kind of hunger for a jurisprudence with more moral coherence. That's what we're reflecting.
Yes, yeah. I mean, to me, it seems rock solid in reading this book. The argument that you lay out, the history that you give us, this is the way to correct the errors that we find within our current legal system. At its root, it is good, but we've lost our way. We need to get back to these anchoring truths and reasoning from there, not just saying, well, this is the conclusion I want, and so I'm going to figure out how to make that work. And it really is just, it's either might makes right, or it is this, the anchoring truths, and reasoning from there. So what a gift you are, Professor Dr. Hadley Arkes. Want to make sure everybody knows the book, Mere Natural Law. You can get that. You can also go to jameswilsoninstitute.org. Any final comment for us in the final 20 seconds here?
No, I think you have it, Jim, and I think you can give as good account of the book as I can myself. So I think I should bring